you for joining us. Good morning, everyone. Thank you for joining us for the panel on going virtual, facilitating or foreclosing the justice system during the 8th annual Access to Justice Week. I start by recognizing that I am speaking to you from Huron County, which is on the traditional territories of the Anishinaabe, Haudenosaunee, and Neutral peoples, and is connected to the dish with one spoon wampum, under which multiple nations agree to care for the land and resources by the Great Lakes in peace. Today, our panelists and our participants are joining from across Canada, from different Indigenous lands and territories. We recognize the long history of all First Nations, Inuit and Métis peoples. We thank all Indigenous peoples who lived and live in these lands on which all of us are on for sharing them with us in peace and friendship. During our discussion today, we will be talking, as I said, about facilitating or foreclosing the justice system through going virtual. As you know, the pandemic necessitated the urgent move to virtual hearings. The move has provided an opportunity to explore the broader modernization of the civil justice system with an aim to making courts and tribunals more accessible and efficient. It's important to understand the experiences of the users of the justice system in this move to virtual hearings. As a result, the National Self-Represented Litigant Project's Virtual Hearing Research Project has sought to gain insights, feedback, and input from self-represented litigants across the country in respect of their experiences participating in virtual hearings. During this panel, the National Self-Represented Litigants Project will report on its preliminary findings from this research. We will also engage in a broader discussion of virtual hearings and the implications for access to justice. We are fortunate today to be joined by 4 very knowledgeable speakers. I will only introduce them briefly because we don't have a lot of time for this very important topic, and we want to hear from the speakers. So more information is found about them in the program information. We have 2 speakers from the National Self-Represented Litigant Project, Jennifer Leach, the Executive Director, and Moya McAllister, the Communications Director. We also have Nicolas Vermeys, Associate Director of the Cyberjustice Laboratory and a professor at the Université de Montréal's Faculté de Droit. As well, we're joined by Lauryn Kerr, who is legal counsel to the Civil Resolution Tribunal of British Columbia. So we're going to get started, and I'm going to turn to you first, Jennifer, and I'm going to ask you to please tell us about the origins of the Virtual Hearing Research Project.
Yes, thank you. And thank you for the introduction. And thank you to the Law Society for hosting us, and particularly Teresa for being so helpful and engaged as a moderator to get us all here today. It was very good focusing in, so I really appreciate that. First of all, this project was made possible with the support from the McLaughlin Fund out of British Columbia. And I'm going to talk briefly about why we undertook this work. My colleague Moya is going to speak to the methodology, and then I'm going to very briefly canvass some of the preliminary findings of where we go. So we recognized, and it went online during the pandemic, but we recognized the potential benefit of virtual hearings as a mode of access to justice. But our literature review that we undertook around the issue demonstrated the absence of the self-represented litigant's voice of the benefits and the challenges of being online. And we recognize as well that the self-reps, the challenges they may face could be different than some of the challenges that are faced, for instance, by judges, adjudicators, and lawyers. So judges and lawyers likely moved online quite quickly, efficiently, and with the support of their firms and courthouse staff. That's not necessarily the case for self-reps. So we wanted to ensure that the self-reps challenges were heard and incorporated to best practices at a very practical level. But even more broadly, we wanted to engage the input of self-reps as an opportunity to explore how proceedings could be heard virtually in a way that encouraged better participation of self-reps. So as we've discussed amongst ourselves, this is not just about mapping Zoom onto an in-court hearing or to existing processes, but really taking the opportunity to the organization of those processes, what's needed in terms of procedure and what is not needed, and how might the processes be reorganized in a more efficient and participatory manner. So that's where we started out. I'm going to quickly turn over to my colleague Moya, if that's okay, to talk about technologies.
Okay. Yeah, so we decided to go with a survey, and that survey launched in April of 2023. We got a really great response. We got almost 200 surveys in French and English returned to us. These surveys came back to us from residents from all across the country. We heard from almost every province and territory, just except we didn't get any surveys from the Northwest Territories, or none of it, which has always been a challenge for us to get into those two regions. From the survey, just our preliminary results so far is we had 32% of the surveys were with a family matter. And then we also had matters in civil, criminal, and administrative. We reached out to hundreds of frontline workers and organizations, especially those that engaged with self-reps. And these included courthouses, legal aid, public legal education associations, law schools, legal clinics, community legal services, and advocacy groups. We also posted consistently on our social media and in our NSRLP newsletter about our survey, and we promoted that. We promoted our survey both in English and French, and we also did a paper version. We had some requests after we initially posted the survey for some people were asking for a physical document that they could fill out. So we also made that possible in English and in French as well. On top of that, we hosted 5 focus groups. 4 of them were with self-reps and 1 was with frontline workers. So when we had initially reached out to all of the organizations to help us get the survey out, one of the questions we had asked them is if they were interested in also speaking to us about their experiences with self-reps and virtual hearings. So we also brought a couple frontline workers into a focus group to get their feedback as well. So we just wanted to make sure that we got as much information as broadly as possible across Canada. Now that our survey is closed, we closed our survey at the end of September, and we've finished our focus groups now. We're about to begin our data analysis stage. We're going to be using certain AI programs to help analyze our data. These programs will be RStudio to clean up data and come up with any exploratory data analysis. And we may also use a program called Spider to conduct regression analysis and clustering. And we're working with a research assistant who is well-versed in these programs and who's going to be helping us collect that data and analyze that data as well. So some of the challenges that we faced was, like I said earlier on, about not reaching some of the provinces, is getting the survey out to remote centers. Those are the people we really wanted to get to, but it was difficult for us to do that. So I know we're constantly trying to come up with ideas of how we can reach self-reps in rural areas. We paid close attention to getting to diverse communities, even in our focus groups. When we chose which self-reps we wanted to speak to, we did take into consideration whether or not they were a newcomer to Canada, a variety of ethnicities, as well as whether or not they were a person with a disability or from the LGBTQ community. We also paid close attention to look for people that are both English and French speaking. So we just wanted to make sure that we connected to as many of the courts across Canada. We not only sent them the survey, but we also put up posters. We had one of research assistants or colleagues of ours in those courthouses. We sent them posters also so that there was a visual aspect to our promotions in the courthouses. Most specifically, Nova Scotia and Saskatchewan did put up their posters for us, and Prince Edward Island put their poster up on their website for us as well. So we are really grateful to those provinces. And then I guess just to wrap up some of our methodology, we definitely had, when we originally worked on our survey, we had a couple people review our survey questions just to make sure that we were capturing the data that we needed to work on this research project. And we just wanted to make sure that we were getting feedback from other people that have the experience and background in this type of work, that they could review that survey. All right.
Okay. And
yeah, go ahead.
so Jennifer, could I just turn back to you and ask you, I know we've heard from Moya that, there's going to be a lot of data analysis. Are you able to tell us anything now about some preliminary findings?
Yes, it's very early days, as Moya suggested. We just finished the focus groups and we just closed the survey, but we've obviously been able to generate some very preliminary numbers, and as well as some observations from the focus groups that I think are interesting and certainly will be explored further. So many of the self-reps that filled out the survey saw the advantages, actually, of virtual hearings. 24% reported that they requested virtual hearings, 32% reported that they were satisfied overall with the experience, and 35% would prefer virtual hearings in the future. So in terms of what worked for self-reps, one is this recognition of the flexibility that's available in virtual hearings. So, don't forget, the self-rep is both client and lawyer. So spending an entire day in court or, going to court is a particular burden on self-reps. And what they recognized is with virtual hearings, they don't spend time traveling to court or waiting in courts. And for those who work or have family responsibilities, that's really significant. As well, some of the individuals who identified as disabled felt that they were better able to participate with their own technology as opposed to whatever technology may or may not be available in court. That was significant in terms of participation. But I will speak in a minute, obviously, taking account of the sort of digital divide that we see amongst sort of the population. The other group that quite liked virtual hearings were legal aid lawyers that were part of our frontline focus group, because they felt that they could handle more files or handle their files in different courts in a more efficient fashion, or tribunals. They're not traveling between courts. They're able to go from hearing to hearing. And that they thought was really an improvement in managing their case files. It's interesting, there's American research out of Indiana that is looking at the same kind of issue. And one of the things that they noted was this idea that evaluations of procedural justice went up for both self-rep plaintiffs and defendants when they were online as opposed to in court, which I think is a really interesting kind of stat to explore. Many of the self-reps, I shouldn't say most, felt more comfortable online. They felt better able to participate. And there's always a qualifier there about tech working. But the comment that came up sometimes was that appearances were less formal. And therefore maybe less intimidating to the self-rep who is appearing on their own. They also noted better resources available to them when they participated from home. So for instance, they could have a printer next to where their computer is. They could have 2 screens. They could lay out their materials in the way that they wanted to. And that they found very helpful in terms of being able to then participate. Again, we'll have to keep that, put a bit of a place mark there in terms of the sort of the divide between who has the tech and who doesn't. Better interaction with judges and adjudicators was one of the sort of very preliminary findings. Anecdotally, someone had mentioned in one of our focus groups that everyone tends to act better when they can see themselves on a screen, which I thought was a very interesting observation from a self-rep. But there's a deeper layer to that, because one of the things about self-represented litigants in terms of assessing procedural fairness is how they were treated in the proceeding. And we know that from procedural justice research, sort of writ large, that is an evaluator. So if that is the case, that people are treated differently, then that's a positive. Now, just to pause for a second and speak to the digital divide. In our survey, about 87% reported easy access to secure and stable internet. 13 reported that they didn't have that. And so I took a moment to kind of look at the stats for Canada tech-wise, and I was actually a little surprised by this. So one stat suggested that about 93% of Canadian population had access to internet, 6,000 of which were through a mobile phone plan. And so we'd obviously have to acknowledge that smartphones are not ideal in terms of a mode of participation. But that is a really high number for internet access. The other sort of broader stat was that 84% of homes had computers, which I was also a little bit surprised by, and maybe my co-panelists may know more about that than I do. But that's all kind of, those numbers are quite encouraging. But then you have to acknowledge that there are vulnerable and marginalized individuals and communities that are lacking high-speed internet, lacking access to computer and the hardware and the technology, particularly remote and in First Nation communities across the country. So there's obviously this great amount of access, but there's also a great divide in the access. About 27% of our surveys indicated that they had difficulty accessing the software that they needed to participate. And this seemed to be particularly challenging for elderly people who were part of proceedings. The fact that there was no kind of consistent online help desk is significant as well. So about a third indicated they had trouble logging on, and a third had difficulty during the hearing with sort of managing the technology, which is not a small number. The frontline workers that we had interviewed were really enthusiastic about the use of navigators and moderators on hearings to really kind of troubleshoot and to assist with all kinds of issues that come up. And when you think about a traditional courtroom, there's registers, there's all kinds of people that are there to assist with things. We need to ensure that's there in the virtual world as well. So the concerns, I think one of the most practical concerns that we saw is a really uneven distribution of information before hearings about how to do it, what to expect. So 36% received instructions, 32% received no instructions on how to kind of conduct the hearing. And about 54% of the surveys were not made aware of any rules or guidelines about conduct during the hearing, which is a significant number as well. By contrast, one of the sort of anecdotal examples was an individual who indicated to us that she had an appellate hearing at a court of appeal, and they did a dry run of the hearing for her, which I thought was fantastic. That's a great kind of way to manage some of these technical difficulties. The other issue that people faced was not being able to access either support people or duty counsel in the context of a virtual hearing. Some breakout room scenarios seem to work much better than others. Again, a lack of sort of consistency across court jurisdictions and sort of geographical jurisdictions. A couple of things that were noted, for instance, where sometimes judges and lawyers would be in the same place, but the SRL would be somewhere else. And that's a serious sort of power dynamic there that is perceived by the self-rep as problematic, potentially. The other issue that came up was this concern that when the self-rep's tech fails, what happens with sort of judges and opposing counsel? There seemed to be a lot of concern. Is the conversation going on without me? And so that seemed to be something that the self-reps raised. And overall, those types of experiences tend to continue to contribute to an overall sense among self-reps of that feeling of being an outsider, of not sort of part of the process, but rather sort of, excluded from it. And so in the context of participating, 35% of the individuals, and all these numbers are a little bit all over the map right now, so we will be kind of putting them all together, but 35% of a particular sort of question about participation said that they did not feel they were able to participate effectively. And they had concerns about noise, about busyness, distraction, being silenced. Again, we have to think, where are kind of lawyers and judges conducting these hearings, and where are self-reps likely to be conducting these hearings, and how do we kind of account for that? Some concerns about security. Who's on the call, who's not on the call, who's recording the proceedings that might be off camera, is private information being disclosed, etc. Interestingly, again, the Indiana research project that just recently kind of wrapped up as well suggested that self-reps in family law cases in which there were issues of intimate partner violence felt safer online than they did in sort of traditional courthouses and courtrooms. We haven't seen that yet, but certainly we would look for that kind of safety consideration as well in family law. One of the things I think too, in terms of information, is this idea of getting self-reps the right information before a hearing, but not overwhelming them with sort of detail of information, either right before it starts or too far in advance. And so thinking about how you prepare an individual for a hearing. And finally, recording. The idea that self-reps would like a formal recording of it because it allows them to sort of catch all the things that they might miss when they're there by themselves. The one place that we saw a really problematic, I think, dynamic is in telephone proceedings. So in the context of virtual proceedings, the most problematic and sort of last option is, lawyer as repeat player with complete internet access and tech support versus self-rep who's calling in with audio only. That dynamic is very troubling in terms of sort of fairness of procedure. So where we go from here, I'm going to very briefly say a couple of things. One, practically speaking, we need to think about, increased and uniform tech instructions. The remote issue is significant. We have places in this country where you can't get internet. That's huge if we're going to do virtual hearings. But also, taking this opportunity to reconsider our practices to ensure that they're necessary to resolve people's legal issues. So what formalities may we consider doing away with? And what aspects of the process are necessary, but may need to be approached differently in a virtual setting? And I think one of the places, and this is why I'm glad our colleague, my panelists are here with us today, is that where we might learn some of this is from ODR processes on how to better structure online hearings with self-reps in mind. So I'm going to stop there. I know I'm almost at time, and I'm very cognizant of staying on time.
Okay, so well, let's talk about that. I'm going to turn to you next, Nicolas. So we've heard the I guess the theoretical, like we've heard about the study and the research and what's going on, and we'd like to hear a little bit from you about what your experiences are, and tell us about the Cyberjustice Lab's work.
It will be my pleasure, and thank you so much for having me. And it's a great pleasure to speak with all of you and to exchange with these panelists, my co-panelists, whom I respect tremendously. And I think the work that you're doing, Moya and Jennifer, is just amazing on these issues. So just to give you a little background, the Cyberjustice Laboratory is a research infrastructure that was launched in 2010. So we're now a teenager. I don't know what that says about us. And the idea was basically to develop a space where research could be made to see how technology can be used to increase access to justice. I always like quoting legal historian Jacques Crinen, a French law professor, who found a quote from 1413 that says, "The problem with the legal system is that cases are immortal and too expensive." I'm paraphrasing here, apologies, a little bit, but that just gives you an idea. The issues that we're facing and that self-reps are facing is not a new one. It's one that's been around for centuries. The big difference is what can be done about it. So historically, the answer has always been the same thing. You need more access to justice, you build more courthouses, and you hire more judges. I think it's Einstein who said what is it? Folly is doing the same thing over and over again and expecting different outcomes. Well, that's what we've been doing, but that's all we could do because that's the only way we could see access to justice being increased. Now our advantage is we realize that while courthouses no longer have to be brick and mortar, they can be digital, and judges don't actually have to be human beings. And I'm not arguing for a robot judge or for artificial intelligence as a judge, but when you actually look at what the courts are doing, a lot of the work that they're doing is just bringing people together and having people speak to one another. Especially when you're talking about self-reps. We've developed a platform here in Quebec called Parlay, a platform to aid in the resolution of litigation electronically, and that's one of the major projects the Cyberjustice Lab has led over the years. Parlay is now being used in Quebec by the Consumer Protection Agency, so basically self-reps, because these are usually cases that only have a few dollars at stake, or at most a few $1,000s, and that falls on under the purview of the small claims court in Quebec, where you have to be a self-rep. Lawyers are not allowed in small claims. And a lot of times what we realize is people settle their disputes not by appearing in front of a judge, because there's actually no judge implicated in the parlay process in Quebec. Simply having the parties speak to one another, just negotiation, and just that will resolve roughly 75% of cases that are submitted to the platform. Now, the same technology is being used elsewhere in the country, where it's used for settling disputes in Ontario. It's used by the Condominium Authority Tribunal in Saskatchewan for provincial offenses. So, for example, somebody who has a traffic violation and knows that they have a traffic violation, but they know that they can't pay it. So instead of waiting a month or 2 months to go in front of a judge to be told you have to pay something that you know you have to pay and you're willing to pay, you just don't have the money to pay it, well, you're just going to negotiate a payment plan, for example. So these types of tools that we've developed over the years, and coming back to what the lab is, so basically that's our mission. Our mission is to see how technology can be used to increase access to justice. And so we have two areas to our work, what we call our techno-legal research, which is really developing these tools, these platforms, but also our social legal research. And this comes back a little bit to some of the elements that Jennifer mentioned in her presentation. And that is, you have to understand why the technology works and doesn't, and why people don't want to use a given technology. She mentioned the fact that, well, the best technology very often is not the best technology. The best technology is the technology that people are capable of using. We work with courthouses around the country and give them, or courts and tribunals around the country, and then just help them decide what technological choices they want to make. And their questions usually revolve around, well, what's the best tablet, for example? Which tablet should we buy? Which is the best one? And I said, well, that's not the right question. The right question isn't what the best tablet is. The right question is, what tablet does the majority of the people in your district use? Now, if most people use an iPad, don't buy a Microsoft tablet, because then they're not going to be able to use it, and vice versa. And so those are the types of things we're doing. So on one side, we're building the tools. On the other side, we're trying to understand what the biggest limits to the use of these tools are. And so when you're talking about more generally about these virtual hearings, well, and again, this comes back to something Jennifer mentioned. In ODR, we realized back in the mid-90s that a virtual hearing does not have to be a video conferencing hearing for different reasons. The video conferencing software at the time was just not available and not powerful enough, and internet connections, for those of you who might, like myself, are old enough to remember the 90s and how long it took just to download through a modem a small picture, and you were just hoping that your sister or cousin or whoever lived in the same house as you did not pick up the phone as you were downloading it, otherwise a connection cut. So you had to deal with the technology of the time, but that allowed us to actually go beyond the simple idea that, well, we're going to have a process, which is the court process as we know it, and we're just going to migrate the exact same process online. And that's what we saw during the pandemic, right? We just said, okay, we have a court hearing, and now we're going to have an online court hearing, and we're going to use the same rules, and we're going to use the same principles, and we're going to expect it to be the same, even though we changed the medium that we're using. And as we know, technology is not neutral. And so the medium that you use will have an impact on relationships, on how people are dealing with one another. And so it's not just a question of transposing things online, which is what I refer to as the first age of cyber justice, right? That's the easy way. It's to say we're just doing the same thing. And there are positives to that, because that's also has the biggest chance of being accepted by the community. If you're just doing the same thing, but a little bit differently, it's a lot less scary than to say we're going to just change the process. But technology actually gives us a chance to change the process and look at what we're doing and see, is this actually useful as a process, or is this process just the way it is because, well, we were using paper for decades, and that's what we built the legal system around, and therefore that's how we have to interact. But when your paper is digitalized, when you have PDF files or interactive files using HTML or XML, well, now you can do things differently. So really, technology is the idea, or is the occasion to create new procedural models and to move away from practices that we've been using for decades, because in many cases we've been using them. I always like asking lawyers, why do we wear robes? And most lawyers don't know the answer to that. They know they wear robes because, well, they have robes. So that's the type of things that we're asking, the type of work that we're doing. If I have more time later on in the presentation, I can talk about a report that we did for the Immigration and Refugee Board of Canada that really came to very similar conclusions as Jennifer's work with self-represented litigants. but I will cede the floor back to you since I think I'm over my time.
Well, I'm going to come back to you though. So we will hear about the research project that you did. Just before I go any further and turn to Lauryn to hear a little bit about what's going on in British Columbia, I just want to encourage people. We do have a Q&A tab, and we've left time at the end for questions. So if you have a question as we're going through this, we'd really love to hear from you. So please put it in the use the Q&A tab, and we'll see how far we get. So, but before we do that and turn to questions, I'm going to turn to you, Lauryn, and ask you to tell us, please, about the Civil Resolution Tribunals, how it uses online dispute resolution. And we've heard ODR throughout this a couple times. So how it uses online dispute resolution to resolve disputes, and the types of hearings that the Civil Resolution Tribunal holds.
Thanks, Teresa, and hi, everyone. I'll start with a brief introduction of what the British Columbia Civil Resolution Tribunal is, just a very quick history lesson. So the CRT is an administrative tribunal here in British Columbia. The legislation for the tribunal was first passed back in 2012, although the work started a couple of years before that. So in terms of being a teenager, at least in concept, we're sort of in the spot as Nicolas and his team over there. And the types of disputes that the tribunal resolves are predominantly small claims disputes up to $5,000, condominium disputes of any value, and a lot of different types of motor vehicle accidents as well. And then starting in 2024, the tribunal is also going to have jurisdiction over claims involving non-consensual distribution of intimate images, and essentially making orders that somebody who's distributing an intimate image of someone else without their consent has to stop doing that, take the image down, etc. So in terms of a model and online dispute resolution, the idea behind the CRT is really to use online dispute resolution as a tool, but in the context of an end-to-end redesign of a civil justice process, to look at how we can help people resolve disputes, and particularly to look at how we can help self-represented people to resolve the dispute. So I really want to emphasize ODR is a tool. It's one tool, but it's a tool in the context of a civil justice process redesign. And part of that redesign comes from the idea of gradually escalating the intensity and resources that go into helping parties to resolve their disputes, and also putting together an end-to-end system where those different phases build on each other. They feel seamless for the user. It's that gradual escalation. If disputes don't resolve at one stage, it moves on to the next. And those phases and those stages, they feel natural to parties. They feel like they flow together, and they're a way that we can help parties to hopefully consensually resolve their disputes. And to focus on that phase instead of working within a model where we're working towards the trial or the adjudication without knowing that that's going to come. And for many disputes in the civil justice system, that day in court might not actually come. The CRT is focused on earlier in the process and focused on how we can use tools, including online dispute resolution, to help people resolve disputes early, but also to save adjudication and save that hearing process as a valuable last resort, because we know that some types of disputes and some people are going to go to that phase. So the earlier stages of the CRT before the hearing, just briefly, we have a legal expert system that all parties will go through to try and help them diagnose their legal issue, learn some self-help tools, prepare them for engaging in a formal legal process generally. And then after that, they'll go into a text-based negotiation platform where they can try to resolve the disputes consensually. If that doesn't resolve, there's a CRT case manager assigned who will work on facilitating the dispute, trying to help the parties resolve it, but also preparing them for the next stage if they do go forward to adjudication. In terms of our hearing model, the vast majority of CRT hearings are resolved based on written submissions, with very, very few oral hearings conducted. And part of that is based on what we've heard from the public in terms of wanting to be able to resolve disputes asynchronously, wanting to be able to log on at whatever time works based on work schedules or childcare schedules or all the different things that people can have going on in their lives. So that's the hearing process. Our tribunal members do have the ability to order an oral hearing if procedural fairness dictates it, but that's a very rare occurrence at the tribunal. And just one final note before I pass it back to Teresa. So the CRT model, like I said, our legislation was first passed in 2012. We didn't open our virtual doors until 2016 with all of the work that went into getting ready for that. But when COVID-19 hit, it was a really interesting way for the tribunal's process and its model to be tested. And one of the things that's quite interesting, I think, is that the CRT did not experience a disruption in service, even for a day, even for a second, as a result of COVID, because we were already using online dispute resolution. Most of our staff already worked from home. For the staff that did work in the office, we had to get them set up to work from home, of course. But from the public's perspective, instead of having to put our process on hold or stop accepting disputes or anything like that, we were able to pivot and really engage with the public and say, like, we know things are difficult right now. What can we do to help you? What can we do to make this process more accessible? And I think a lot of that stems from the CRT's use of online dispute resolution and how we can adapt to this new reality.
So let's just pick up on that a little bit, where you're saying, how can we help? What can we do for you? How does the CRT integrate a user-centered approach into its work?
Yeah, the user-centered design of CRT processes was really essential, not only to getting the tribunal up and running back when we were doing all of the design work, but also on an ongoing basis. And I really want to emphasize that ongoing part as well, because I think there's a tendency a lot of times in the justice system to design and build something and then say, okay, that's done, we're going to use it, pat ourselves on the back and proceed with things. So the user-centered design, it started when we were first launching the tribunal, first looking at this piece of legislation where we had a mandate to help people resolve disputes in a way that's more accessible, more efficient, more proportional to the nature of the disputes. But what did user testing look like? So when we were first trying to figure out how to design the tribunal, there was a lot of outreach with the public, a lot of different focus groups, a lot of different surveys. And that's one of the places where we heard a bit about how many people were online. Like Jennifer mentioned, the digital divide, the stats were a little bit different back in 2012 or so, but looking at the digital divide, looking at how people wanted to resolve disputes, looking at asynchronous dispute resolution processes. So all of that happened when we were looking at how to design the tribunal. But one of the things that I think we come back to a lot when we're doing user-centered design is looking at the people that have the most barriers to accessing the justice system and trying to get away from talking to lawyers, talking to judges, talking to people that are quote unquote insiders in the system that might not find the Supreme Court processes all that scary, and instead looking at people that have not worked in a justice system, that maybe have never used a legal system, or maybe people that are marginalized or have barriers in other ways to accessing the justice system, and trying to talk to those people, trying to get their feedback, and designing a process that at its core is simple enough to work for people that have no experience with this. And then knowing that if we can build something that's that simple, people that have more experience will hopefully be able to adapt. And sometimes it turns out with the CRT, it's sometimes the lawyers or the people that are expecting more process or procedure that end up finding it hard to use a really simple process. And in my books, I think in some ways that to me is a sign that we've done what we've intended to do by designing something that is less procedurally complex and that works for the public.
Okay. And is there anything else you want to tell us in terms of the importance of the use of user-focused design principles in the justice setting?
I would just emphasize the focus on consulting with people that are the users of the process instead of insiders, instead of lawyers and judges, and then also continuous improvement. So I talked a little bit about how it's not just about designing it and getting it out the door, but one thing that we do at the CRT is we collect statistics every single month from people that have gone through our process, asking, did you feel treated fairly? How was your interaction with staff? Did you have the information you needed? Would you recommend the CRT to others? And we have a survey. We also gather free text comments, and we're able to look at that and sort of keep our finger on the pulse in terms of trends, how it's working, what's not working, and then we can use that to keep on improving and changing as well.
Okay, so we do have a lot of questions. But Nicolas, I'm going to go back to you. Maybe just briefly to tell us about that report that you just told us a tiny bit that you were going to tell us about it. So let's go back and hear a little bit about that.
I'll try to be very quick. So
That's
basically,
okay. We have time, so it's okay.
You're opening a door here, though. But right after the pandemic, we were contacted by the Immigration Refugee Board of Canada, who, like many courts or tribunals across the country, were using Teams, or in certain cases Zoom, but basically video conferencing to hold their hearings. And they quite enjoyed using it. They being the deciding, but the judges, which are actually called members, and some of the parties. At least that was that's what they believed. And so they asked us to conduct a study, basically to confirm whether or not they should continue using it, and in which cases, and so on. And so we surveyed over 270 participants in the process. The individuals that are asking for refugee status, as well as their representatives and representatives from the state. And what we found was that there was a relatively high satisfaction rate. So what we were measuring was their sense of access to justice. And so did they feel that these tools were allowing them to have access to justice? The result, and this is a number that gets mentioned in the media, was an 86% rate. Now, these statistics, I always like to say, they're, to quote Benjamin Disraeli, there are three types of lies, damn lies, and statistics. These statistics you have to take with a grain of salt, because although 86% seems very high, and it is, what we don't have is a comparative. We don't know how well or not received in-person hearings were, because we never evaluated in-person hearings before the pandemic. So we still need more data. And conducting this study, there were a lot of elements that we found out, some of which were mentioned by the other panelists. Things like, well, some people felt more comfortable because they were in their own homes to discuss, and it was less formal. Now, I would say in certain cases that's problematic, because if it's less formal, people don't necessarily realize the importance of the process. And in this case, obviously, if you're a refugee or requesting refugee status, it's an extremely important process. One thing that I found was probably the most interesting, and this comes back to Lauryn's last comment, is that very often the evaluation of litigants and their legal representatives were very different. So in certain cases, the litigants thought, "Oh, this is great. I feel like I have access to justice," and their legal representative was saying, "Oh no, I don't think that my client got access to justice through this process." And so you can tell that very often the interpretation isn't the same for the self-represented litigants and for legal professionals. And what we found in other areas is that the reason for that very often is lawyers tend to look at everything through a legal lens, not necessarily a pragmatic lens. And just a very quick example of that, there's a judge that did an informal survey when people would appear in front of him to register their plea in criminal proceedings. They had a choice to do it through video conferencing or in person. And he would ask them, why do you choose video conferencing or in person? And the lawyer will say, well, it's either to save time or to have access to the court. And their main reason was food. The food at the courthouse was better than the food at the jail. Well, that's a rationale that is totally outside the scope for lawyers. So we have to understand why litigants like or don't like the technology, and it's not just a question of legal processes.
Okay, so I'm going to move on to some of the questions, and we have a fair number, so I'm going to sort of amalgamate a couple of them. So, Nicolas, earlier you talked about intimate partner violence. And one of the questions was, in that kind of case, and there may be many other cases like it, for example, even immigration and refugee cases, some of the nonverbal things that are happening are really, really important. Shaking, crying, sweating, hyperventilating, like the things that if you were in the presence, not the virtual presence of, but the actual presence of, might be easier to pick up. And another question asked, which I think is quite similar, is the eye contact as well, and those kinds of connections. So I want to offer it up to maybe I'll start with Nicolas. Just briefly, any reflections, thoughts on those issues?
Definitely it is an issue. Now, I personally believe, and the data backs me up on this, that it's overblown as an issue. And the reason for that is we have a tendency to overestimate our capacity as human beings to evaluate nonverbal signs. And every study, every serious study that was made shows that we're actually not as good as we think we are. So we have a tendency to think that we know what people actually mean when we're reading their nonverbal language, but it's not necessarily the case. Now, that's not to say, and one of our conclusions in the report was there's a lack of humanity linked to an online process. I have an example of a gentleman that was crying during a hearing that I witnessed. Well, there was nobody there to just go here. So you have to find a way, yes, to recreate this humanity. And for the eye contact, well, it is an issue. Right now, I'm looking at you, but I'm not looking at the camera, and therefore I'm not looking at you. Now, that can be fixed with the technology by buying putting the screen at a certain distance, moving the camera, which can be done in a courtroom, which can be done when you have the proper tools. But as Jennifer mentioned in her presentation, that's not always the case for self-represented litigants.
Okay, I'm going to just go on to the next question. Okay, and I'm going to turn to you, Jennifer, for this one. One of the questions then was, now that there's a move to virtual, can that leave litigants spending their strategic preparation time adapting their evidence to virtual? And the question is, should consideration be given to the fact that self-represented parties don't have an administrative support system to do these tasks? And does that create a strategic imbalance?
I think the short answer to that is yes, and it's not inconsistent with the other kind of strategic imbalances. So, when we started this project, we recognized that it would have been a lot easier for some of the stakeholders to go online than self-represented litigants. And so that kind of imbalance gets replicated in all kinds of different aspects of the process. So absolutely, there has to be some way of, and maybe it's an informational piece, that there is now kind of an administrative imbalance, but it was there before as well. Let's not underestimate that when an individual was going to an in-person hearing and they were binding all their materials and organizing sort of their motion records and getting their evidence in order, that was all done by them. Whereas, lots of lawyers have the assistance of an administrative staff to help them do that stuff. So that imbalance was there. The question is, we have an opportunity, as Nicolas was saying, to do things or think about them differently. What would that look like to be more supportive from an administrative standpoint with the preparation of self-reps cases?
Okay, so there's a question about, did the survey ask self-reps whether they were allowed a choice in virtual versus in person? And secondly, did you find any significant differences in responses among the various diversity groups? For example, where the self-reps mother tongue is not English or French?
Right. So we haven't done the slicing of data that is sort of categorized by sort of different aspects of diversity, language, culture, background. We haven't been able necessarily to do that yet, but we do have some numbers. Just kind of quickly, we did ask the question about whether you prefer virtual to other modes, and the numbers are 47% would indicate that they prefer in person, 35% would prefer virtual, 9 had no preference, 7 would prefer hearing in writing, and 2% would prefer telephone. So really, really small amount for telephone, and we can understand why that would be the case in a lot of instances. So those are, again, caveat on all of these are very preliminary numbers, and we'd like to be able to kind of run some analysis of that to see, who's saying that, where they're saying it, who's picking which mode over the other, and what that might tell us about where we need to sort of direct support.
Okay, so we have a few more questions, so I'm going to keep going. So I'm going to ask this one of you, Lauryn, and it might be too broad, so tell me if it is. But one of the questions was, what are the thoughts on AI, artificial intelligence, and does it streamline operations? Does the potential outweigh the risks? Could it ease burdens? Should there be human monitoring? Any thoughts on sort of the any thoughts on this? And the question was framed from staffing or resource allocation from a management perspective. But where does AI fit into what we've been talking about?
Yeah, that's a huge question. I think I can speak to that from the CRT's perspective. So we are not using artificial intelligence generally yet, and that's something that since we opened in 2016, that we've actually been doing a lot of work the opposite direction. And I think you see that with online dispute resolution, like a real need to provide transparency into what the process looks like, and the fact that there are humans behind the process. Our decision makers are still people. Because I think with online dispute resolution, it feels a little bit a black box to people, particularly if you haven't been involved in it. So assuring participants in our process that there are people behind the tribunal, that there are humans, decision makers that are making the decision. That's most of what we've done so far with the Civil Resolution Tribunal. We are looking at how artificial intelligence could help us provide better services to people. From a resourcing perspective, I think there are likely ways that we could look at using artificial intelligence to streamline things, to decide disputes more quickly. And then it comes down, I think, really to the question of what kind of human oversight do we need? How can we use artificial intelligence as a tool? But again, just one tool among many in our toolkit to help people better resolve their disputes. And what I personally am thinking a lot about right now is how artificial intelligence can be used in a way that can help self-represented parties to better understand the law or to better understand the case law, and how can we find ways to use that as a tool and put that into the hands of the public in a way that will work for them.
Okay, anything to add to that, Jennifer?
Obviously, we are very interested in thinking about AI in the context of access to justice. I happen to be speaking with an adjudicator from a federal tribunal, and one of the ways in which we were even thinking about it is sort of the pop-up kind of Q&A that could be made available on websites for adjudicative tribunals to answer ongoing questions that come up about procedure and such. So there's no doubt a lot of ways. AI, I think right now it has all kinds of potential and all kinds of risks, and it's trying to figure out how you manage the potential to the benefit of both self-represented litigants and the kind of organization of civil justice more broadly. But yeah, we think about it pretty much every day.
And Nicolas, anything to add to that?
Well, the issue is, how do you define AI, right? Lauryn said they're not using AI. I would actually beg to differ. I think that it's the CRT is an AI platform. It's just not machine learning. It's not large language models, which is the AI that everybody is talking about right now. But when you look at the official definition of AI, or I should say the first definition of AI from the 1950s, which is when a machine acts in a way that would be considered intelligent if a man or human being acted in that way, the CRT is absolutely AI. But when you're looking at the modern forms of AI, so machine learning, large language models, and so on, there are ways of using it. In fact, at the lab, we developed a tool called the Justice Bot that basically can interact with a self-represented litigant. And depending on the questions, their answers to the question, then it will give them access to case law that has a similar fact pattern to their own case, so that they can have an idea of how courts will decide in similar cases and help them better refine their legal arguments.
Okay, so I think we have time for one more, and this is one It's kind of a comment, it's kind of a question. And it's about case lines or case management systems, and about whether they would help the represented parties by giving them a more global view of their overall job, and sort of breaking down sort of the information and sort of the steps that are coming. And they're just wondering, though, about use of that in for self-represented. And do you have any thoughts on the use of something like case lines? Is it a helpful sort of system to assist case self-reps? Is it a barrier for self-reps? Do you have any thoughts, or is that any information that's being collected?
So right now, I don't have a sort of a final thought on it. We have had some people note that they struggled with CaseLine to access it appropriately. They didn't feel that there were a lot of instructions on how to make use of it. But certainly, again, we would say that if there's a means by which not only the individual can access put the documents on and access them, but to see what's coming, that's significant from a self-rep's perspective. One of the things we know about representing yourself is, you're always kind of running to catch up to the next event. So to the extent that that is sort of laid out in front of you, leading up to some kind of hearing or proceeding, would overall be helpful, so long as the technology is accessible and sort of explainable, and therefore usable by the self-reps. But
Well,
certainly something we
okay. Thank you so much to, first of all, to the people who joined us. We are grateful that you took time out of your day, that you're interested in access to justice, and that you were with us to participate in this fabulous panel discussion by our very qualified panelists who provided a lot of insight on facilitating access to justice as we look at the virtual model and the virtual world that we're dealing with. So thank you to our panelists and to everyone who came. Thank you very much.
And thank you for for moderating this. It was very helpful.
Absolutely.
Okay. And thank you, Lauryn and Nicolas, for joining us as well.
Thank you.
It was a
Across the
great
country.
pleasure. And I can't wait to read the report.
Yes, well,
Yes.
we're just getting started now on that, so we will move as quickly as we can.
Thanks,
Well,
everyone.
thank you and have a great day, everyone.
Thanks, everyone.
Bye. Bye.